Well, hello and welcome to another episode of the Legal Gym Podcast. Thank you so much for joining me here today, where we're going to be talking about the differences between trademarks and copyrights. Riveting, I know. For the show notes for today's episode, which will include all the links and resources for everything I'm going to be discussing today, make sure you head on over to hawthornelaw.net/14. That's the number 1414. All right, let's go ahead and dive into today's episode. Now, before we get into all of the amazing content for today's episode, I wanted to let you know about a new training that I'm currently working on. I'll be teaching my 4R framework to get your trademarks registered quickly and easily. In addition, I'll be sharing the top 3 mistakes I see online entrepreneurs make that can sabotage their brand and even force them into bankruptcy. So if you want to sleep better at night knowing that your brand is legally protected, you don't want to miss this free training. Just head on over to hawthornelaw.net/trademark to get notified when the training is live. That's hawthornelaw.net/trademark. And don't forget, everyone who attends this training will get a free gift from me. So if you're an online entrepreneur who is building a brand online, then this is one training you definitely don't want to miss. One more time, go on over to hawthornelaw.net/trademark to get signed up for the notification list today. So today what I want to talk about is, like I said, the differences between trademarks and copyrights. And so we're going to be talking a little bit about what trademarks are. We're going to talk about what copyrights are. We're going to talk about how you can register those two things. And then we're going to talk about which you should prioritize in your business today. Because I get a lot of clients that send me messages like, hey, I need to copyright the name of my business. I get that they want to copyright the name of their business. What they really want to do is they want to protect the name of their business with a registered trademark. But, I'm not judging. This stuff is tricky, and I can tell you, until I started doing it, I've been through law school, I've been through 2 bar exams, and even I did not understand fully the differences between trademarks and copyrights until I actually started working and handling trademark applications for clients. So let's just jump into it, okay? Now, trademarks and copyrights are both different forms of intellectual property. Now, when we're talking about intellectual property, you may have heard the term intellectual property lawyer. This is a lawyer that helps people to register trademarks, to handle copyright issues. Sometimes they do patents, although to be a patent lawyer, you have to pass a special bar exam. And then also, they sometimes will help companies with what we call trade secrets. So if you've ever heard of the secret recipe for Coca-Cola, that is a trade secret. It is a type of intellectual property. It's the only type of intellectual property that does not need to be registered with the U.S. Patent and Trademark Office. So trademarks and copyrights are both different types of intellectual property. Now, let's talk about what each of them actually is. So the definition of a trademark is a symbol, word, or words. It could also be a logo that is legally registered or established by use, that means common law use, as representing a company or product. So this could be your business name, it could be your logo, it could be a slogan that you use with your business, it could be the name of your podcast, it could be the name of a product or a course that you sell. All of these things would be considered trademarks. Now, what's important about this definition is it says that are legally registered or established by use. So what that means is you can have a trademark. In fact, anything that you use in your business right now that kind of identifies you in the marketplace as your business, it could be, like I said, your business name, logo, slogan, podcast. You own the trademarks to those by virtue of the fact that you're using them because they are established by use. So you have what are called common law rights. The problem with common law rights is that there's not a whole lot of teeth to common law rights. So we're going to talk more about that in future episodes, but that is what a trademark is. Copyrights, on the other hand, are the exclusive legal right given to the originator of a work, or it could also be somebody that you assign the rights to print, publish, perform, film, or record literary, artistic, or musical material, and to authorize others to do the same. So basically what a copyright is if you go and write a blog post, then you own the copyright to that blog post. When I put this podcast episode out, then I own, and even without publishing this podcast, I own the rights to this audio recording of my voice. So if you want to think about it, a trademark is kind of like, if you go to the store and you want to buy something, a trademark is like the packaging. It's what identifies, let's say, all right, I've got a good example for you. So yesterday I had to go to Target to buy a pair of shoes for my daughter. And it's funny because all the shoe boxes, they're all different. They all have different colors. They have different logos on the side of the boxes, different things like that. The packaging that contains the logo or the name of the company that sells the shoes, that is the trademark. The copyright is the stuff inside. So the copyright is the design of the shoes that somebody has created. That could be, if you wanted to consider that an artistic product. Now, why this is important to online business is because you have to think about the packaging as how people perceive you in the marketplace. So if you have an online course, your trademark is the name of your signature online course. If you have a YouTube channel that you have named something unique, then your trademark is the unique name for your YouTube channel. If you have a podcast that you've named something, that is the name of your podcast. But the copyright is, in the case of an online course, it's all the material you put into the online course. The copyright is the videos that you upload to YouTube. The copyright is all of the audio recordings for your podcast. So hopefully that makes sense and kind of simplifies the differences between trademarks and copyrights for you. Of course, when I publish this, if you have any questions, you can feel free to send me a direct message or a DM on Instagram at jim.hart. If you've got questions about these type of things, feel free to send me a message. I love to hear from people on Instagram. So let's talk a little bit about, now that you know kind of the difference between trademarks and copyrights, let's talk about what the process is like to actually register a trademark. Now, it's interesting because when you start using a name in commerce, you own the trademark rights to that. You own the common law trademark rights to that. Maybe. When you take the affirmative step of registering with the U.S. Patent and Trademark Office for a trademark, what you're doing is you're basically telling the U.S. Patent and Trademark Office, hey, I'm using this name in commerce, and I want the federal rights to use this name. And then they will look through your application and decide whether or not they're going to grant you the federal rights to use that name. A trademark is hard to get. You have to prove to them that nobody else is using this name in commerce, that there's no what they call likelihood of confusion between your mark and another mark. And an examining attorney at the U.S. Patent and Trademark Office is going to be the person who is going to look through and do a search and determine whether or not that you can actually move forward with that name. And if you can't, then they're going to tell you. So the way to get a trademark is first you have to do your own search to make sure that nobody else is using your name. Then you file the trademark application. Then you wait a super long time. Right now it's taking about 8 months for applications to get assigned to an attorney. And then at that point, maybe they will send you something and ask you to respond to some requests for clarification, or maybe they just deny your trademark outright. You have to overcome that. So then you respond to whatever it is they send you. And once you've gone through that hurdle, then they basically publish your trademark. And so this is where they put it out there and say, hey, does anyone else have any claims to this mark? If so, speak now or forever hold your peace. It's kind of like if you go to a wedding. And assuming nobody is going to respond, a lot of times people don't, but it does happen sometimes that people will come in and notice that somebody filed for something, and then they will go ahead and file an objection to that mark. Then the trademark will get registered. So as you can see, it's a hard process. It's a tough process. We recommend you use a lawyer to do it. Obviously, I'm a lawyer. I help people with trademarks. So that's the trademark process. Now, the copyright process still takes a little bit of time, but it's easy to get. Basically, you send a copy of your work into the Copyright Office with a small fee, usually $35 to $55. I think it's gone up a little bit in recent years. And they basically, after waiting 6, 7, 8, 9 months, they will send you a certificate saying that your copyright is now registered with the Copyright Office. Very easy to do. So the question becomes, and I should also say about copyrights, the system is set up to protect people who are registering their copyrights. They want to protect artists. They want to protect artistic integrity. So versus trademarks, where the system is set up to basically protect the public from people selling knockoff brands. And that's why it's so hard to get a trademark, because they don't want somebody coming in and registering a name that's deceptively similar to another name and then selling an inferior product, because that hurts the public. So it is very hard to get a trademark. It is much easier to get a copyright. That's another key difference between the two, which comes down to which should you do first. Should you do a trademark? Should you register your trademark? Or should you register your copyrights? Well, with a trademark, like I said, you do have common law rights when you start using the trademark, but those rights are somewhat limited, and they're not going to stop somebody from basically coming in and stealing your brand and registering it on their own. And if they do register it with Trademark Office before you have registered it with the Trademark Office, then you have to go in and show that you have the common law rights to that and that you've been using the name. And even in that case, it's expensive and time consuming, and there's no guarantee that you're going to win that argument. So my recommendation is typically that you need to protect the name of your brand that you're using, and make sure, and this is another key point of filing your trademark application, is make sure you're not accidentally infringing on somebody else. Because two things can happen when you file a trademark application. You can go through and you get your trademark, then you can sleep easy knowing that you own the rights to that name, or you can get refused and they'll tell you, hey, there's this other brand out there that has a name that's very similar to yours. And then okay, I've got a problem. I need to come up with a different name. So we recommend doing a comprehensive search to try and avoid that second issue, and then going ahead and registering your trademark name. Now, the thing about your trademarks is, especially when it comes to your business name, your podcast name, these are things that likely are not going to change very often ever. So you don't want somebody to steal or claim the rights to the name that you're using by filing a trademark application before you, because rebranding is expensive. Cease and desist letters, if you receive one from another company that's using the same name as yours, those can be stressful. So in order to really own your name, you need to register your trademark with the U.S. Patent and Trademark Office, and then you can know with absolute certainty that you own the name to that brand and nobody's ever going to be able to take it from you. With the copyright, on the other hand, if you are a content creator, as most of you probably are, you're going to have a lot of content, whether it be podcasts, videos, blog posts, social media posts, all sorts of things. And you own the copyright as soon as you create the work. I already mentioned this. So nobody can steal that from you. And if they do, there are mechanisms in place where you can actually get those, whatever they steal from you, taken down. I'll give you an example. Somebody stole a blog post from me and posted it on their website. So I used the Digital Millennium and Copyright Act, or the DMCA, legislation to actually get that person to take down their blog post. Now, they didn't take it down. I actually had to go to the web host for the blog that was hosting the content, and they took that post down. So you need to make sure that you're monitoring and you're protecting your copyrights, but at the same time, you own that copyright as soon as you create the work without taking any affirmative step of registering it with the Copyright Office. This is very different than how trademarks work. Now, when you register your copyrights, the reason you're doing that is because now registration is required to bring a lawsuit in federal court for copyright infringement and to seek statutory damages. So that's a really good reason why you should be registering your copyrights. But as I said, if you're a content creator, you're creating a lot of content, then you probably want to register a batch of content at one time. And you can do that once a quarter, once a year, once a month, whatever your frequency is that you think that you need to do it. That's when you should do it. It costs, like I said, I think it's around $50 or $60. I think I mentioned 35 or 55 earlier. I think the fees have actually gone up, but it's relatively inexpensive, and you can do a bundle of posts and content at one time. So this is something that's ongoing. You're always going to be monitoring and registering your copyrights as long as you're in business. So the bottom line here is I do recommend that you register your trademarks before you worry about your copyrights. And the reason for that is it's a one-time thing for the name of your business or the name of your product. Now, you might register multiple trademarks over the years, but when you're just getting started and you want to make sure that you claim the name of your brand, then it's really important to get that first trademark application in, and then you can worry about copyrights, later on down the line when you have some content that you need to protect. So that's what I've got for you today. All of you legal gym listeners, now that you know more about copyrights and trademarks, you are ready to implement, because if there's one thing we love to do here at the Legal Gym, it is to take action. So if you haven't already, make sure you check out the show notes page for today's episode. I kind of recap everything we talked about here today. You can get a rundown of all the links and resources we talked about by visiting hawthornelaw.net/14. That's hawthornelaw.net/14. That's going to be the home base for all of your legal and business tools and resources to help you start, build, and protect your online business. Thank you so much for listening today, folks. I look forward to seeing you in the next episode.